Good morning, this is Melanie Daly here with the Daly Grind. This is a new series that we are doing where we are sipping our morning coffee and we're just going to discuss workers' compensation issues. If there's anything that you'd like to hear about, then we are welcome to suggestions and we like to cover what you're interested in. So please feel free to reach out to us at any time with any topic that you would like to hear. Today I'm going to talk about Section 137, which, as you all know, is one of claimants' attorneys' favorite things to bring up on our IME. They look for any violation of 137 and they are very quick to raise it and try to get our IME precluded, which of course sets us back, especially if it's a good IME opinion. So we always want to make sure that our IMEs are in compliance with 137, or at least we can argue that they did substantially comply with the statute. However, not many people are aware that you can actually also bring it up when it comes to a treating provider's opinion, which is one of our favorite things to look for, especially if we have a claim where the claimant either has not treated in a long time or there is only one exam from this particular doctor that we're about to depose. So we always keep an eye out for that. If he's been treating with other providers and then all of a sudden this new doctor comes in with this SLU opinion, this is outrageous because they usually are, and we look throughout the treatment records and we see that he hasn't treated him before, our feelers go up and it's something that we like to look for, especially when we're deposing the doctor. So when we start the deposition, we're always asking them, how long have you treated the claimant? Usually they'll say, well, he really only came to me for this permanency opinion. So you didn't treat him in any way, and he'll say no. So that's at that point is when we would raise 137, as he would have been required to list all of the records that he referenced, and he would have been required to send the report into the board in the same manner as required in 137, and that's when we raise the issue against the doctor and we try to get that report precluded, because they are, even though they consider themselves a treating provider, if they have not actually rendered any treatment to the claimant, then they're basically an independent medical examination and 137 would apply to them. This is a little trickier in cases of initial treatment for causal relationship, because a lot of times we will see that he goes to one doctor for an opinion on causal relationship. However, there are board panel decisions that support that 137 does not apply in those cases, because there is a presumption that the claimant was going to continue to treat with the doctor, and the doctor usually has a treatment plan for the claimant in those cases. So 137 is not as successful in those situations. However, if you do have a permanency opinion from a doctor that you have not seen before, something should go off, and when we go into the deposition, we will make sure that we ask the doctor. And also, we are sure to raise the issue of 137 on the record during the deposition, because there is also case law that indicated that if it was not raised when you first knew that it was not a treating provider, then you untimely raised it if you waited for the hearing to do so. So we prefer to do it on the record at the time of the deposition, indicating that the claimant just testified that he has not rendered any treatment to the claimant, he does not have any plan to render any treatment to the claimant, and the claimant simply came to him for a permanency evaluation. And that's when we move to preclude the doctor, and therefore our IME would stand as the opinion for permanency. If you have any questions or any comments on this topic, then feel free to reach out to me. And if there's anything new that you'd like to hear, as always, please feel free to reach out. My email is mdaly@madwcdefense.com. Thank you.